This is Bart Peterson, and you are listening to the FCPA Compliance Report on the Compliance Podcast Network.
This is Greg Gilchrist, and you are listening to the FCPA Compliance Report on the Compliance Podcast Network.
This is Dan DeMarco, and you are listening to the FCPA Compliance Report on the Compliance Podcast Network.
In this episode of the FCPA Compliance Report, I'm joined once again by fan favorite James Koukios. James is a partner at Morrison & Foerster, and we take up the firm's November 2020 newsletter for international anti-corruption developments. Some of the topics include the OECD report, lauds U.S. enforcement efforts and increased enforcement efforts by the Netherlands, the World Bank debars, a German firm. We take a look at anti-corruption developments in Mexico and concerning Venezuela, particularly around export control. Conclude with a discussion of China and its repatriation of fugitives to stand trial in the country of China. I know you'll enjoy this episode with James. It's always great. I also hope you will check out my new podcast, ComTech, on the intersection of compliance and technology with my co-host, Valerie Charles. It's available on the Compliance Podcast Network. Check it out. I know you will enjoy it. Hello, everyone. This is Tom Fox back for another episode, and I'm thrilled to have back with me my good friend, James Koukios, partner at Morrison & Foerster, to talk about the always great firm monthly international anti-corruption letter. James, first of all, welcome. And I would note for our audience who cannot see you that behind you, it's snowing.
It is snowing, and I'm also going to note for our audience that can't see you, Tom, that you are wearing a Michigan football sweatshirt, which I highly approve of.
Well, in spite of our season, go blue.
In spite of our season.
James, I wanted to visit with you to start with. We had the OECD report released, and you've talked a little bit in the past about your work on these OECD reports, but I was wondering if you could maybe review for us what the OECD process is, how they do it, why they do it, and what their findings were with regard to the United States in this most recent report.
Sure. So the OECD is, of course, the Organization for Economic Cooperation and Development. And one of the many things they have is the Anti-Bribery Convention. And the members of the Anti-Bribery Convention have a very rigorous peer review system where the different convention members review each other in terms of how they are complying with the Anti-Bribery Convention. It's a very detailed process. I was actually part of it for the Russia Phase 2 evaluation. It's a very lengthy questionnaire that's sent to the country. The country then answers that. There can be several rounds of follow-up between the OECD staff, the examining countries. There's 2 examining countries for these. So there can be a lot of written back and forth. And then depending on which phase it is, there's also an in-person stage to that. And so the 2 examining countries, along with the OECD staff, will go to the country that's being examined. They'll meet with the leaders from that country for several days, and then they'll meet with civil society groups, law groups, and others outside of the government to also discuss anti-corruption issues as well. And so they're evaluated on all parts of the Anti-Bribery Convention. Does the law, does the foreign bribery offense match with the elements in the Anti-Bribery Convention? Are there sufficient means of publicizing the anti-bribery offense? Are there anti-money laundering provisions being pursued? How is the international mutual legal assistance cooperation going for that country? It's a very, very intense process with a lot of different parts. And then when that's done, the OECD staff and the 2 examining countries write a very lengthy report where they set out the findings of these. And then that goes to the plenary at the OECD Anti-Bribery Convention Working Group. People debate the merits and the findings. The country being examined can file objections, seek clarifications. There's basically a big peer review of the report. And then once that's done, it's released publicly. They're really, in my opinion, they're really great reports. The OECD staff in particular are real experts on international law. They really get to understand the laws of the various countries and the systems. The examining countries, usually the people on the examining country staff, like I was, are enforcement attorneys, so they have a really good insight into, the prosecution investigation process and things like that. We also had Commerce Department experts, State Department experts, a lot of subject matter experts to help evaluate it. And it results in a very good, very thorough report. And I always tell people, if you want to learn about the legal landscape when it comes to enforcement and anti-bribery and things like that in the country, you should read these things because they're really good. And they have a lot of impact. There is a lot of teeth behind these, and the OECD over the years has used these reports to really praise developments from certain countries and to shame other countries into doing what the working groups thinks they should be doing. So, a lot of people say, and I think it's true, that one of the impetuses behind the UK Bribery Act, for example, was a very negative OECD working group report on what the UK was doing in terms of their enforcement of the foreign bribery offense. Similar, the Brazilian Clean Companies Act, a lot of people credit that to OECD evaluation as well, and not solely, but in many ways. And so they're very impactful reports, and I recommend people read them, and they really do have an impact.
So what were some of the highlights for you from the analysis of the U.S. Enforcement?
It was a very interesting report in how positive it was. The Phase 3 report was back in the early 2010s. And at that time, the U.S. was, head and shoulders above every other country in terms of enforcement. I mean, they'd been doing it longer, they've been doing more, but the working group still found things to criticize. Very interesting this time around in 2020, there was very little criticism at all. It was amazingly positive. I mean, the words like praised were used in it. The report praised the United States for its sustained commitment to enforcing the foreign bribery offense and other activities the U.S. was taking. And if there were any recommendations or criticisms, they were relatively minor and very technical. So the U.S. got a glowing A+ report card as part of this, which is really interesting. And that you don't usually see such a positive report, especially for how lengthy and thorough it was.
So if I could now turn to also a report on the Netherlands, and it seemed the OECD report on the Netherlands, and they applauded the increased enforcement efforts. What was your analysis of that report?
The Netherlands was a little bit more normal or typical, I'll say, because it was, there's positives and negatives. So you're right. You picked up on the positive, Tom. The report favorably noted that foreign bribery enforcement had ramped up in the Netherlands. And among other things, they credited that to that the Netherlands established specialized investigative and prosecutorial teams to really focus on the foreign bribery offense, and that the Netherlands did a very good job working with international law enforcement partners in cooperation. Those are things that the U.S. has obviously done as well, and the Netherlands has done those things as well to good accord, according to the OECD. That said, the OECD was a little balanced there. They said, relative to the size and risk profile of the Dutch economy, the Dutch are very involved in international commerce. They export a lot, things like that. The OECD said they still weren't doing enough cases relative to what the Dutch economy looks like. And so they recommended some additional ways that the Dutch could potentially improve that. It was interesting to me because just the month before, in October 2020, Transparency International had released a report, and they were very critical of the Dutch enforcement record for the foreign bribery offense. And I remember reading that thinking, well, that's unusual because many of the big resolutions over the last couple of years, including with the U.S., the Dutch have been involved. A lot of the oil cases, the Operation Car Wash cases, the Dutch have been involved. And I was surprised by how negative Transparency International was about the Dutch. And I felt the OECD report reflected a little bit more what I understood to be the Dutch record, which is, of course, it could be better. That's true for most countries. But they've been pretty active, and they've been really cooperating with their international counterparts. So that's the takeaway that I got from the OECD report on the Netherlands, which was, generally doing a very good job, an active player in the foreign bribery space, but could do more.
So now I'd like to turn to a debarment of a German company by the World Bank. And here, James, I really wanted to use this as a way to maybe have you explain what the World Bank's role in the fight against anti-corruption is, and how they use debarment as a tool that many other countries really don't use, and how it's a little bit different.
Sure. So, obviously, at the risk of stating the obvious, the World Bank gives loans for development projects in the developing world, and those can be high-risk jurisdictions. And when those loans are being used for development projects, they're susceptible to all kinds of malfeasance, whether it be fraud, embezzlement, or in this case, foreign bribery. And the World Bank has been pretty active in trying to police all those things. They want to make sure that their funds are used for proper purposes and not improper purposes. And so they have an incentive, and they have pursued foreign bribery allegations as well. Now, they're not an enforcement authority. They can't get anybody to plead guilty or go to jail or anything. But what they can do is they can debar companies from doing World Bank projects in the future. And so they use that as their sanction primarily in these matters. And so here that's what they did. They found that this German company had been involved in some improper conduct in Myanmar. Sounds very similar to many foreign bribery cases you'll hear about. There was failure to disclose a commission paid to a local agent, and then improper travel for 3 officials related to the project. And so the World Bank was careful to note that even though the company was debarred for 2.5 years, that was a reduced penalty because the company provided extraordinary cooperation and took voluntary remedial actions. So very similar that we would see with DOJ or SEC enforcement. The World Bank is also trying to credit cooperation and remediation as well. And I'll also note, Tom, oftentimes, not always, but on occasion, the World Bank does work with local law enforcement as well. So, when I was at DOJ, the World Bank talked to us on occasion about certain cases. Same in other countries as well. They're willing to share information and be, although not law enforcement, be kind of that law enforcement partner as well. It doesn't always happen because the cases that the World Bank pursues aren't always FCPA violations or rise to the level of a criminal offense. But there are certain occasions where the World Bank does interact and cooperate with law enforcement authorities around the world.
So now I'd like to turn to Mexico. And I guess the first kind of overriding question is the political relations between our countries. They seem to have been at least colored by some recent actions by the State Department, by the Department of Justice, and by the Mexican officials. I don't know if that would impact people who do what you used to do as a line prosecutor, but I wondered how some of the overriding concerns between our two countries might negatively, or I shouldn't say negatively, impact the ability of the Department of Justice to bring corrupt officials to justice.
As you well know, and I'm sure many of your listeners, the U.S. and Mexico have always had a very delicate relationship when it comes to law enforcement. On the one hand, they're great partners. There's been a lot of cooperation in the anti-narcotics and anti-money laundering sphere. On the other hand, there's always we've got a delicate history going back where the U.S. has invaded Mexico and gone to war with Mexico, and there's always a concern on the Mexican side that the U.S. is overstepping its bounds and maybe trying to exert too much influence in Mexico. So there's always a delicate trade-off between the two countries where we want to cooperate where our law enforcement interests are aligned, but the Mexicans are always a little bit skeptical of us in terms of overreaching. And we saw that happen in November. There was a big case, really it happened in October of 2020, where the U.S. arrested a former Mexican general and accused him of accepting bribes from a drug cartel. The allegations were interesting. They basically said that this Mexican general had accepted bribes from one particular cartel to ensure that the military actions were only undertaken against that cartel's rivals. I mean, if you ever read in any of the books by the cartel or any of those books, really it was like ripped from the headlines. It was really interesting to me, the whole favoring one cartel over the other and things like that. So that was the allegations, that this general was basically taking bribes from one cartel to go after other cartels. And when that general flew into Los Angeles in October 2020, he was arrested. And that was a big deal. There was I think it's a fair characterization to say there was outrage from the Mexican government. And so much so that some public reports suggested that Mexico had threatened to expel DEA agents from the country. And basically, long story short, the U.S. ultimately agreed to dismiss the charges against this general in November of 2020 and send him back to Mexico. But as an outreach of this, there was some discussion by various Mexican officials that this would reduce law enforcement cooperation between the two countries, and Mexico would make sure that they would Mexican officials could only be prosecuted in Mexico. They wouldn't cooperate with the U.S. authorities to prosecute Mexican officials in the U.S. Now, who knows how long that's going to last? It's possible that could blow over. We have a new administration. Maybe that was just over aggressiveness on one side or the other. But it could make these things more difficult. The bribery has also always been a little bit of a touchy subject because that really does in some ways implicate state sovereignty. When the U.S. is accusing a Mexican official of bribery, that can be seen as an attempt to impinge on Mexican sovereignty. So that's always been a fraught area, but we saw it really come to a head in October and November. And we'll see if that really continues or not. There's a big underlying investigation going on right now involving Pemex, the national oil company in Mexico, where there are allegations, and who knows how credible there are, but successive Mexican presidents were involved in bribery involving Pemex. There was a Wall Street Journal article a couple months ago saying that the U.S. and SEC have opened up foreign bribery investigations on the same topic. That will be really interesting to see if there is actually cooperation in that case, both generally and in light of this new development where we had this dust up between Mexico and U.S. about corruption allegations. So we'll have to wait to see how that plays out, especially under the new administration, and to see how the foreign policy relations between the two countries evolve.
So, first of all, in Texas, we would not say the United States invaded Mexico. We would say Mexico invaded Texas. So,
fair enough. I was taking it from the Mexican standpoint in that regard.
But we also saw Mexico pursue some corruption allegations against a Mexican official and ask and receive from Spain the right to extradite a former Mexican government official who was living in Spain back to Mexico. So I found that there was at least some news positive around an anti-corruption type perspective.
Right, and that was the case I was mentioning before, this big Pemex investigation. And Spain did extradite a former Pemex president back to Mexico to stand trial for some alleged corruption involving Pemex when he was in charge. And he has apparently, according to reports, implicated several former Mexican presidents and other former high-ranking Mexican officials in alleged corruption schemes. And that's the one that DOJ and SEC have reportedly opened up investigations on. And just wanted to follow up on one point. I mentioned the book, The Cartel. And of course, there's also The Border and The Power of the Dog, all by Don Winslow. I don't know if you've read those, Tom.
Trilogy.
The phenomenal books. And having worked a little bit in that area, the international cooperation in narcotics between Mexico and the U.S., I think those books are fantastic. You learn so much about the history, even though it's obviously historical fiction, but it really does give you some good sense. And that's when I read this story about Mexican General Salvador Cienfuegos taking bribes to help one cartel over the other. I thought I was reading a Don Winslow book, not Reuters or Bloomberg.
Let me turn to the country that keeps on giving in the world of anti-corruption and FCPA, and that's Venezuela. And what I'd like to start with is Citgo, and I would like to start with that because that's a Houston-based company, so there's lots of interest here around what's happening to Citgo. But on the flip side is the U.S. government has, I think, moved towards classifying Citgo as a instrumentality of the Venezuelan government because of their ownership of the company. And we've seen, I think, a few cases, enforcement actions, I should say, previously, but this really is, I would say, a little bit new development because Citgo is domiciled in the United States, although once again owned by PDVSA, the national oil company. So I wonder maybe sort of what your thoughts are around Citgo. Are you guys getting questions on this? I know I am here in Houston, and it seems to me to be a very delicate situation that we all need to, if not tread carefully, tread with consideration.
This is a fascinating case. This was an investigation that started even when I was in the department into PDVSA, the state-owned oil company of Venezuela, where there were allegations that various companies and business executives were paying bribes to PDVSA purchasing agents to get contracts and to get paid and things like that. And it's been a whole series. I think it's 20 plus people have been charged in this thing, been very successful. And when they started out, they were really, very closely tied to PDVSA. And now, as you said, Tom, we're now getting to Citgo. And it is really fascinating to see what will happen in terms of whether courts will agree that Citgo is an instrumentality of the Venezuelan government. So just a little background here. In August of 2020, DOJ announced that it had charged a former Citgo petroleum company procurement official with money laundering. The theory there was he was a foreign official because he was an official of Citgo, and that he received bribes to steer business advantages to various other companies. They couldn't charge him under that theory with an FCPA violation because under that theory he's an official himself, and so they charged him with money laundering. Well, he actually admits he did all that. He said he essentially admits that he took the bribes, and he essentially admits that he steered business to these companies in exchange for those bribes. But what he says, and he filed a motion in November of 2020 asking for the government's specific theory on how he's a foreign official. So in other words, I took the bribes, I took them in exchange for giving this business benefit, but how are you going to prove I was a foreign official for purposes of the FCPA? And DOJ responded that it will prove at trial that Citgo was an instrumentality of the Venezuelan government. On the specific issue, they said we don't need to provide you with our roadmap or, give you advanced notice of exactly how we're going to do that. But they said we are going to go to trial and we are going to prove that Citgo, this Houston-based U.S. headquartered company, is an instrumentality of the Venezuelan government. And I think it's going to be fascinating. I tried the Eskenazi case, which led to the only appellate court decision on how to determine whether a company is an instrumentality of a foreign government. It'll be really interesting to see how DOJ applies that in this case. I don't know all the facts of Citgo, so I can't opine on that. But I think it is, as you rightly point out, Tom, very fascinating that a U.S.-based company could potentially be considered an instrumentality of the Venezuelan government. So we'll have to wait to see how this plays out. But I think this is a really important case to watch for people working in this space.
So if I could complicate it even more a little bit, the current board of Citgo was appointed by Nicolas Guaido, I believe is his name, but the other president of Venezuela, that the one that's recognized by the United States and the United Kingdom. And so that's in the United States. Of course, PDVSA does not recognize those board members, but the U.S. government does. And so we have the even more anomalous situation that the sitting government in Venezuela, who's alleged to Citgo's alleged to be the instrumentality of, actually doesn't control Citgo. And I'm in groups with compliance groups here in Houston with people who are employed in Citgo, and they, are either very concerned or very confused. And I think many of the contractors to Citgo, it's kind of percolating down to their level that they may have been a supplier, they may be in the plant, they may have done work for years for Citgo, and now they're looking at, has our relationship changed? Because the U.S. government has said in this one lawsuit, you are an instrumentality of the federal government. I pose all of those not as having answers to them, but just a series of questions that has really arisen in a very different way.
It'll be that's interesting facts, Tom, and it'll be really interesting to see how this plays out for sure.
James, unfortunately, we're near the end of our time for this episode, but we're going to link to the November International Anti-Corruption Developments newsletter. So I look forward to seeing what December might bring us.
Thanks, Tom.
Hello, everyone. This is Tom Fox. Thanks so much for listening to this episode. I'm extraordinarily pleased to announce the pre-publication pre-sale of my latest book, The Compliance Handbook, 2nd edition, published by LexisNexis. It will be published in April. Quite simply, this is the best single volume, single author book on compliance programs. The creation, the design, the implementation, and the enhancements of best practice compliance programs are all laid out in this book. If you're in the compliance field, in the compliance discipline, this is the book for you, far better than any other book on the market, if I may say so myself. I'm going to link to it in the show notes for pre-sale. There's also a discount. Thanks again for listening to this episode of the FCPA Compliance Report, and I hope you'll join me again next week for another episode.